Okay, everyone, I think we're ready to go.
Yes.
Okay, Madam Clerk.
State of Wisconsin versus Javier Smith, 25 CF 4509 appearances.
Dan Flaherty for the state, appearing on behalf of ADA Vance Cruzan.
Good morning, Judge. Attorneys Anthony Cotton and Christopher Donovan with Javier Smith. He's here in person in custody.
All right, good morning, everyone. We're all in court today for a plea hearing. I understand the parties reached an agreement and amended information has been filed with the court. I'll start with Mr. Flaherty on that agreement.
Thank you, Judge. The state has offered the following resolution to Mr. Smith. If he enters a guilty plea to the amended charge of second-degree reckless homicide, use of a dangerous weapon, the state would dismiss but read in count 2, which is possession of a dangerous weapon by a person under the age of 18, and at the time of sentencing, recommend substantial prison to the court, and of course the defense would be free to argue at time of sentencing.
Mr. Cotton?
Yes, that's correct.
Right. And then amended information has been filed with the court. Has the defense received it?
We do. We're going to enter a not guilty plea to that and waive its reading.
Okay. And the court accepts the plea then pending my discussion with Mr. Smith about this change of plea. So, Mr. Smith, I have a number of questions for you about your plea to make sure you understand what all this means, okay? I see you nodding. I will need you to answer out loud, though, okay?
Yes. Yeah, I understand.
Okay. All right, let's pull that mic down and a little closer to you. There we go. Thank you. Okay, so, Mr. Smith, now, do you understand with this amendment to the charges, count 1 has been amended to 1 count of second-degree reckless homicide with use of a dangerous weapon. This is an incident from September 21st of 2025 involving the death of Azoria Jones. This is a Class D felony. The maximum penalty for this offense is a fine of up to $100,000 or imprisonment for not more than 25 years or both. And sir, do you understand if the court accepts your plea today, that's the maximum sentence the court could order in this case?
Yeah, I understand.
Okay. Now, if the case were to go to trial, the state would have the burden of proof. They would have to prove certain facts or elements. First, they would have to prove that you caused the death of Azoria Jones, and this would be on September 21st, 2025. Second, they would have to prove that you caused her death by criminally reckless conduct, meaning that your conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. And the state would also have to prove that you used a dangerous weapon. Here, that would be a gun. And do you understand that those are the facts the state would have to prove if the case went to trial?
I understand.
Okay. Right. Now, do you understand also that the court, that means me as the judge, the court is not a party to the plea agreement. So when we get to the sentencing date, the attorneys will each make recommendations, but the court does not have to follow the attorney's recommendations. And you understand that?
I understand.
Okay. Now, I also have to advise you that if you are not a citizen of the United States of America, a plea of guilty to this offense could result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. And you understand that, sir?
I understand.
Okay. Also, if you are convicted of this offense, because it is a felony, you will not be allowed to possess any gun or other firearm in the future. And you understand that too?
I understand.
Also, if you are convicted of this offense, you will be required to provide a biological specimen, that means a cheek swab, to the Wisconsin State Crime Lab for DNA testing and to pay a DNA surcharge. And you understand that as well?
I understand.
Okay. And if you are convicted of this offense, because it is a felony, you will not be able to vote in any election until your civil rights are restored. And you understand that too?
I understand.
Okay. And also, if you are convicted of this offense, because it is classified as a violent felony, you will not be able to possess body armor at any time in the future. And you understand that as well?
Yeah, I understand.
Okay. Understanding all these potential and mandatory consequences, how do you want to plead then as to the amended charge? Are you pleading guilty or not guilty?
Guilty.
Okay. And I have those plea forms in front of me that were filed by your attorneys on your behalf. Those forms indicate that they were signed on May 14th. Does that sound correct to you?
May 14th when we went over him in the jail.
Yeah, it's correct.
Okay. Do you remember reviewing the forms with your attorneys before you signed them?
Yeah, I remember.
Okay. And when you reviewed the forms with your attorneys, did they answer any questions you had to your complete understanding and satisfaction?
Yeah, they answered them.
Okay. Do you have any other questions about what those forms say?
No, I ain't got no questions.
Okay. Now, the forms talk, among other things, about your mental health. Regarding your mental health today, Within the last 24 hours, have you had any drugs, alcohol, or medication?
No.
Okay. Is there any medication that you're supposed to be taking that you have not taken?
No.
Okay. Right. And Mr. Cotton, have you reviewed these plea forms with your client and explained the contents to him?
Yes, Judge, Chris and I went over this together with Mr. Smith in the jail.
Okay. All right. And Mr. Smith, these forms talk about your rights in the case. Do you understand you're giving up those rights by entering this plea?
Yeah, I understand.
Okay. So the forms talk about a number of your rights, including the right to bring motions and also your right to assert a defense to this charge. You understand you're giving up those rights by entering this plea?
Yeah, I understand.
Okay. The forms also talk about your right to a jury trial. That is the right to have a jury of 12 people hear all the evidence in the case and decide whether you are guilty or not guilty of this charge. Do you understand you're giving up your right to that jury trial by entering this plea?
Yeah, I understand.
Okay. At a jury trial, the state would have the burden of proof. That means the state would have to prove each of those elements that I described earlier, showing beyond a reasonable doubt to the satisfaction of all 12 jurors that you committed this crime. Do you understand you're giving up your right to make the state prove that case at trial?
Yeah, I understand.
Now, also at trial, you would have the right to testify and the right to remain silent. Also the rights to call witnesses to court and to cross-examine the state's witnesses. Do you understand you're giving up those rights as well by entering this plea?
Yeah, I understand.
Okay. Except for the plea agreement we've been talking about, has anyone made any promises to you or offered you anything to try to get you to plead guilty?
No.
Has anyone threatened you or tried to force you to plead guilty?
No.
Right. Mr. Cotton, are you satisfied this plea is being made freely and voluntarily?
Yes.
Okay. And have you gone over all the discovery materials with your client?
Yes, Judge, that includes the police reports, video, and a lot of other materials. I just would note, as you probably have observed, that Mr. Smith is, I think, still 17, right? You're still 17. Still 17. He was only a few weeks after his 17th birthday when he was charged. So he's very young, very close to being a juvenile defendant. So I think we've taken extra care here to really go through the materials, both Chris and I, to make sure he understands everything.
Thank you. Mr. Donovan, do you agree you've also participated in those reviews of these discovery materials and discussions with Mr. Smith?
Yes, Your Honor.
And you agree that he's making this plea freely and voluntarily?
I believe so.
Okay. Right. Mr. Smith, have you had enough time to talk with your attorneys about your case?
Yeah.
Are you satisfied with the way they are representing you?
Yes.
Okay. Right. At the beginning of the case, the state filed a complaint. The complaint describes what the state believes happened on September 21st, 2025, that led to the death of Azoria Jones and your actions on that date that caused her death. And sir, have you read that complaint?
Yeah, I read it.
Did you review it with your attorneys?
Yeah, I reviewed it.
Okay. Do you have any questions about what the complaint says?
No.
Okay. So the complaint explains why the state believes that you committed this offense. Is what the state says in the complaint substantially true and correct?
Yes.
Right. And Mr. Cotton, are you satisfied there's a factual basis for this plea?
There is a factual basis. Mr. Smith ultimately acknowledged to the police what happened.
Okay. Mr. Donovan, are you also so satisfied?
I am.
Right. Mr. Smith, do you have any questions before we continue?
No.
Has anyone told you anything that is different from what I've told you in court today?
No.
Right. Mr. Cotton, are you aware of any reason in law why the court should not accept this plea?
No.
And Mr. Donovan, same question.
No, Your Honor.
Right. Mr. Flaherty, does the state consent to the jury waiver?
It does.
Based on our discussion, the court approves Mr. Smith's waiver of his right to a jury trial. May the court use the facts as stated in this complaint and the facts admitted by Mr. Smith in court today to stand as the factual basis. Mr. Flaherty
Yes.
and Mr. Cotton.
Yes, Your Honor.
Mr. Donovan.
Yes.
On that basis, the court finds that Mr. Smith is entering his plea freely, voluntarily, intelligently, and with full understanding of the nature of the charge as amended, the maximum possible penalties, and all the rights being given up by pleading guilty as to count one as amended. The court further finds that there is a factual basis for the acceptance of this plea, and the court accepts the plea. Mr. Smith, based upon your plea of guilty to this charge and the factual basis for that plea, the court now finds you to be guilty of this offense in the manner and form as charged in count one of the amended information filed today. And I judge you convicted on this date, June 4th, 2026, and I order judgment of conviction entered in the record. As agreed by the parties, then, the court does dismiss and read in count 2 for sentencing. Is either party asking for a pre-sentence investigation?
No.
No. Mr.
No.
Flaherty? No? Okay. All right. And do we have a sentencing date, Madam Clerk? No? Okay. Let's find a date off the record.
We do have a date, Judge.
Oh, we do?
Yes, we pre-selected with Mr. Vance Curzan.
Okay.
The 23rd at 3 o'clock
Okay.
of July, I'm sorry.
Understood. Okay. Back on the record, Madam Clerk, with that date. Oh, sorry.
Sentencing hearing is July 23rd, 3 p.m. in person, room 506, the Safety Building.
Okay. The court does order remand for sentencing. Was there anything else today? Mr. Flaherty?
No, thank you.
Mr. Cotton?
No.
And Mr. Donovan?
No, thank you, Judge.
All right. So, Mr. Smith, you took responsibility today. That's a big step. It's a consideration the court will take into account when we talk at sentencing, okay? All right. Thanks all.
Okay.
Court's adjourned.
Thank you. We'll talk to you, all right?
Y'all gonna come see me tomorrow?
I'm not gonna see you tomorrow, no, but I'll, we'll come see you to get ready. All right, I see the press is here, so I'm gonna go talk to them, and,
Oh, you do that. Yeah. Hey, Sanjit. Hey, Judge. How are you? Good, how are you? That's okay. What is it right? We only have one? Is that right? Okay, yeah, okay. Yeah, I know. Yeah, I'm about ready to.
Just want you to stand up a little bit so I can scoot you back and have the seat, okay?
All right, no cell phone usage in the gallery. If you need to use your cell phone, step out in the hall.
Folks, yeah, you can't use your cell phones here. Ladies, you got to put those away. I understand you want to take pictures, but you can't in the courtroom. Thanks, ladies. We'll see you.